If you or your loved one is facing domestic violence charges, you may have heard something called the fast track program, or the idea that domestic violence cases in Colorado are fast tracked. I want to delve into what that actually means, both legally and realistically, so that you can get a little bit further understanding of what a fast track DV case in Colorado looks like. Now, in the state of Colorado, there's a mandatory arrest law that says if there is an allegation of domestic violence and there's probable cause that a domestic violence charge has occurred, the person must be remanded. In other words, they must be taken into jail, taken into custody immediately. There are no ifs and buts. Mandatory arrest law says if there's a DV charge and there's probable cause for it, that person's getting arrested. Now, what that means is we end up with a lot of people in jail who don't deserve to be in jail. People with first-time offenses, people with minor domestic cases that really should never have been an issue, except for they were doing something that they shouldn't have been, like maybe they were yelling too loudly or they were texting too much. You can be thrown in jail for a domestic violence charge for any range of charges. But the problem becomes that with that mandatory arrest law, you are in jail immediately after you're caught. So in order to fast track this program, what Colorado does is they say, okay, anytime that you're charged with a domestic violence charge, you must be seen in front of a judge in order to argue bond as quickly as possible. The general rule of thumb is between 24 to 72 hours. Now, technically, it should be before 24 if there's any way possible, but with the weekends and different docket loads, it could take longer. Generally speaking, though, within the first 3 days that you are arrested, you will be appearing before either a judge or a magistrate in order to be given a bond. The reason I say given a bond is because that mandatory arrest law in Colorado exists, you are placed on a no bond hold until a bond can be set in your domestic violence case. So if you know anything about bonds and other charges, let's say, for example, there's a drug charge and an arrest warrant goes out saying, okay, we're going to place a $50,000 bond on this person. If they get picked up, they have to pay $50,000 to get out. In domestic violence cases, it doesn't work that way. If you're arrested, there is no bond set. You have to wait until your hearing to even get a bond set. So that's why these programs are fast-tracked, to allow that person to have the opportunity to argue bond at the soonest possible available date that the judge or magistrate has. Now, at that date, the named victim or the alleged victim, the person who is the one who either called the police or the person that's the one that's described as being the victim in the case, has the opportunity to say what they want the judge or the magistrate to know about bond in this case. Now, under the Colorado Constitution, victims have rights in domestic violence cases just as much as defendants do. They have the right to be heard, they have the right to appear at hearings, they have the right to have input on what the district attorney offers in charges. So victims have the right to appear at this date for the bond being set and any modifications made. That's why it takes a little bit of time, because the DA has to reach out and make contact with the victim to get their input. At that bond hearing, a bond is then set based on typical bond schedules and based on the person's criminal history or lack thereof, their stability, their involvement in the community, and the severity of the charges. Now, once the bond has been set, the person can then bond out. There are a couple of different kinds of bonds that we go into in more detail in other videos, but once the bond has been set, they can bond, and then there's another court date that follows very quickly thereafter. That is an advisement date where they have to sign their protection order in the domestic violence case, and we've talked about those protection orders in other videos before, but that's why you have the arrest, the person is put into jail, they're given a bond hearing, and then they're immediately given a court date thereafter, and things happen in very quick succession. So that's why we say it's a fast track program, because it's the best way I describe it is it's kind of a hurry up and wait situation. So when you're charged, things will happen very, very quickly. But once you get to that final court date where you're getting advised of the charges that are being filed against you, you have your protection order, then the case starts to move in the normal course. And generally what we see, at least here in Colorado, is cases typically are set about 3 to 5 weeks out, depending on the judge's docket. So you have that first, just initial hell week, to be quite frank. You go through all of this, you go to court multiple times, you're dealing with all of it, and then it gets into more of that typical docket rhythm that we see with other cases. So that's why we call cases fast-tracked in domestic violence charges here in Colorado.